Yeah, yeah, yeah. So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit of accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge, they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. It is Pam Esquire, also known as Your Law Intellect. I am here in Georgia, boots on the ground. We have a hearing tomorrow. We have court, social media jurors. For those of you that are new here, welcome. For those of you that have been rocking with your girl for a minute, welcome back. I appreciate the support. This is the way you start the show out. Only Me 23 has gifted a membership. Welcome. Welcome to the person that got the membership. We appreciate you, and we appreciate you deciding to go ahead and give somebody else with a membership. So yeah, I am here, boots on the ground. You guys know how I do. We got court in the morning. We have court in the morning on the Ernest Williams case. For those of you that don't know who Ernest Williams is, first of all, I have to say, where have you been? Where have you been? Because we've been talking about this for the last year. Ernest Williams is the now ex-husband of radio personality Shirley Strawberry of the Steve Harvey Morning Show. And he has been accused. There are a lot of allegations. There are financial crimes that have already been before a grand jury, and there is an indictment, including a RICO charge. And on tomorrow, there is a plea/trial, I think is what they call it. But I presume, I don't know if he was offered any type of plea deal. He seems as if he doesn't want to take one regardless, but I don't know if he was offered one. But there was a motion that was filed that was argued the last time, which was a couple of weeks ago, I believe September 16th. The only time I didn't come and everybody was in there running amok, people were trying to shut up all the bloggers. We wasn't considered media. It was a lot going on, and I wasn't able to make that actual hearing. But nonetheless, of course, we had the video because we do have a videographer that comes over here and captures all of our legal footage so that we don't miss a beat and we feel like we were there. Well, Ernest Williams is still fighting, as he should be. I told you guys that it would not shock me that in the next coming months that we would see motions, and this is a motion to suppress the evidence. Excuse me. And that is exactly what I figured would be the next step. That would be the next step. Some of you guys are so funny because what y'all think, this man is not supposed to fight or something? I mean, you guys in the comment like, ugh, rolling your eyes and stuff. They were DMing me like, are you going to go over this whack motion? I was getting all type of, I'm like, what y'all think? His attorney's supposed to sit back there? We have a job. We're supposed to be zealous advocates for our client. And if he can pull this motion off, then that means that everything that was in that truck would be what we call fruit of the poisonous tree, and it would be thrown out. That would be a nice victory lap if he was able to pull that off. So that's what you're supposed to do. You're supposed to fight zealously for your clients, And so that's what his attorney is trying to do right now. You know what, DC Lively? You guys are, whew, my God. It that Hoover is earning. He's doing his job. You guys are so funny to me. That's why I was like, so when I started out, so we had a flight for this morning, and my initial live was going to be to talk about Eric Adams, because we talked about Eric Adams on yesterday. Shoot, I'm getting my days all mixed up. Okay, we talked about Eric Adams yesterday, and his attorney basically vowed that he was going to come for the government because they were leaking information. Well, his attorney did file something asking that the government be sanctioned, and he attached were they affidavits? Yeah, I think he attached an affidavit from a lawyer who had been sending letters to the government because they felt like it should be an investigation, because since they've been investigating Mayor Adams, the New York Times has been getting a whole lot of inside information. Like, they knew that Mayor Adams from New York was going to be indicted the day before. So there's letters going back from like June of 2023. So he's been being investigated for a while, where they've been asking, they being Adams' legal team, they were asking to have an internal investigation because of all these leaks. So I was going to talk about that. Then I turned around and Diddy got 100 and something people that this law firm in Houston is alleging. I haven't even watched the whole press conference because I'm kind of diddied out. I'm going to be perfectly honest. If it's something that's just like, okay, I got to talk about it, then I will. But I think a lot of the content creators, they're covering the hell out of this situation. And I get it, and I appreciate that you guys want my take on every little thing. But I just can't comment on every little thing. But I did see part of the clip that was on the Shade Room, and they got the 1-800 number, and they are alleging that there are victims from the ages of 9 through whatever age, and they're trying to do what's called a class action, which, yeah, they have 100 and something lawsuits. So what you do is you ask the court, Judge, can you certify us as a class so we can have one lawsuit? And usually you have specific plaintiffs, probably the most egregious ones, and then you have people that just join the class, and then you get you a settlement and everybody splits it up, or you go to trial, and then if there's a verdict, then everybody splits it up. And of course, it's for judicial economy, because that's a lot to have 120 cases going on for a similar situation. So let me see. So there's that. Okay. So I figured I'd at least touch on it, because maybe tonight, if I get some time, I'll go ahead and maybe go over, because the Eric Adams situation is very interesting, because I've kind of wanted to know how the people knew all the stuff about Diddy. It was pictures of the raid. It was pictures of what was in the when his premises were searched. There were pictures that were leaked about that. So I was kind of wondering how some of this stuff was getting out too. So I think it's a legit question or legit concern. You know what I'm saying? So I'm going to keep my eye on that. Starfish and Coffee said, I'm done with Diddy. I don't know what y'all want from me. I don't know what else I can add. Diddy has added, if you guys are in my membership, I did put information in there that Diddy has added additional attorneys. So he has an attorney. His name is Anthony Rico, and he is out of New York, and he specializes in complicated defense. I think he's done like death penalty cases and all of that. And he's been a super lawyer, so he seemed like he all right, you know. And then he got an appellate attorney on this team, because he's trying to get, for the third time, he said third time's a charm. He's trying to get out on bond. And the way these allegations are coming, I can understand and appreciate his attorney's argument that it will be very difficult to fight all of these allegations with him behind bars, because especially in the detention center for federal court. They have certain time frames that you can be there to do your visitations with your client, as opposed to if they're out, you can go to your office and be with them all day long. I can see why they would at least go through whatever lengths that they can to try to get them out. So that's happening on that end. And then even with Eric Adams, he's added a law firm in DC along with, and I guess it was the law firm in DC that was actually sending the letters that was representing him when all of this stuff started happening, when he was under investigation. So that's who the FBI and AUSA were in contact with, was this DC firm. So now they've entered an appearance. So everybody's lawyering up. They lawyering up. They're getting the heavy hitters. You guys remember with the OJ situation, how you had the dream team. Sounds like they getting the dream team. Oh, Lord. So Gloria said, with the suppression be for the CP cases too. So the CP cases are still unindicted. They're still unindicted, but I would surmise if this is the warrant that started everything, meaning that the phones, remember there was some type of pictures, and we're on Ernest Williams now. I know we all over the place right now. But with Ernest Williams, there were alleged a device, and this device was found during this search, which he is trying to get this search warrant, get all this stuff suppressed. That if it happened in this case, then of course he will probably try to do it in the other case if he's indicted on that. But right now he's still unindicted on the case. It's just sitting there. So, but I would surmise if it works in this one, you're gonna do it in the other one. Even if it doesn't work, maybe you get a judge that looks at it differently. Simply Me said, I can hear Sonia Ernesto comparing him to Diddy. Quote, they are trying to take all the successful black men down. Thank you for the super chat. But yeah, you're right. It's the comparisons a lot of times just ain't comparing, like they shouldn't be comparisons, but that's that. But yeah. Hey Sarah, I seen you in my DMs. I didn't get a chance to respond. I was just getting to this room here. When my son was there, the lawyer told me plenty of times he went to do a legal visit and was not able to get to see him. It was a mess. Yes, this is from For Always to Ever for Life, which I assume you're talking about that detention center over there in New York. Yes, like it's different. Like even in state court, when you're in even if you're in state court as opposed to federal, they do have visiting times. Sometimes they try to monitor it, all type of stuff. But federal apparently is a lot worse. The few federal criminal cases that I had, and a very, very few that I've done civil there, but from a criminal standpoint, they were out on bond. So I didn't have that, I didn't have that issue. But I did hear, you're not the first person that said that, and specifically at that detention center, that it's very hard for you to meet with your client. So he deserves a defense. I know everybody can't stand him. Everybody is upset. A lot of this stuff, many of us heard it for years. So it wasn't really a shock factor for me. A lot of these allegations and rumors and innuendos have been talked about for years. So Bible lady said, I ran over here so fast that I forgot to thumbs up the video. Don't be like me. Hit that like button. Yeah, listen to Bible lady. You see she over there saved. You got to be saved to know Jesus to name yourself Bible lady. We know where that came from though, but And I haven't done this in a while either. Let me go here. We missed Dre.
And another thing you notice, the first thing they say, make sure you guys hit that like and the subscribe button. That's what it's all about. After they get them dogging you out, before they dog you out, that's the first thing they say. If you like this video, make sure you hit.
You have 1 minute remaining.
I forgot. Listen, I haven't even put that up in a while. It's been so much going on. We haven't even, we've still been covering Mr. Williams, but it's been kind of few and far between. Make sure y'all hit that like button. Subscribe to the channel. We appreciate the love. Get us in the algorithm, So we're going to get into this motion again. If we have time, then maybe I'll get into some of these other situations that happened. But I'm going to be honest. When I touched down in Georgia, your girl was tired. I was so tired. I jumped in this bed so fast. Well, you know how you sleep so good, you wake up and you think it's morning. Like, I know I laid down at like 11 or 12 or noonish type situation. But when I got up, I still was like, oh man, I didn't call my clients back. I was supposed to do this. I got to check my emails. When you wake up, that's how you know you tired. Then we were on the plane. I slept too. And Deb was like, oh my gosh, you're going to have to control your snoring. I was like, really? That's what we're doing? He was like, you kind of loud. I was tired, okay? So I'm grateful. Kathy Darling said, hi, Pam and Intellects. Love being here for 6 months. I love you being here for 6 months. Let's pull this up. I see you guys coming in. Starfish said, the judge talked to all the media pool and someone screenshot the image from a court TV screen. Miss Love wants the media out. We talking about YSL now. So with YSL, are you talking about, because I missed your comment. Obviously, I'm over here just yapping. But are you referring to, there was a situation of which people were screenshotting, I guess, her laptop? So like I saw it on Twitter or X, and it showed Love like turning the screen, and she was typing, and there was a detective that was on the stand, and we're talking about YSL. See, we all over the place over here. We in everybody's courtroom right now. And she was typing, and then people were trying to infer that she was giving him information or something crazy. It's a lot. Yeah, it's a lot going on in that YSL. That's a lot. I mean, she has to shield her. I would do that. I do that when people are behind me in the gallery, let alone you got all these cameras. And why would the cameras be trying to zoom into her laptop and stuff? Like, why are you doing that? You're supposed to be in the courtroom so that you can, it's like we're all allowed public access, and you're giving us public access around the world. So why even zoom into, like, you're trying to zoom in and see what she typing and zoom in and see? Like, that's a bit much. Like, I get it. A lot of people are over this trial. I was over it probably 6 months ago. I do think it's a waste of time. I think that, I don't know what's up with the DA, but she does seem a bit unorganized. It's all over the place. Everybody seems like they testify and they just become a big name. Their subscribers go up. Their followers on Instagram go up. TikTok, they become TikTok sensations. And it's all become almost a joke. But at the end of the day, you really do have real men that are facing some real time, and it's a real case, but it's turned into such a ish show that I can totally see why people are over it. But some of this stuff is like, come on, people. Like, we really just gonna start trying to look at what the DA is typing, then make all these inferences that you're doing things that are, nefarious in some way or whatnot, and you're sending them messages through your laptop. It's just, Jay Vic said, why don't she have a glare-free private screen? I would assume, honestly, she probably, okay, so when you get your Rule 22s, you're supposed to like do the courtroom. Like, why would you think that somebody is even looking like they would try to look at your laptop? But I understand, I get what you're saying. You should take all precautions because you don't want it out here, but that's a lot. Now that one I don't know what Miss Love, you know what I'm saying? I didn't watch it today. Obviously, I was trying to get here, but I could see her trying to have an issue with media if that's what they're doing. Miss Love had her laptop facing the camera, and then she entered in her password, must have thought about it and then moved her screen. Okay, that's from Vic DeVille. Thank you so much for letting us know. I've seen her move her laptop a few times. It's almost like you start doing it and then you realize like, oh, it's cameras here. Let me make sure it's out of the view of the camera. And she's turned it. Now, people were making it seem like this is the first time she ever did that when this detective was on the stand. That's not true, because I've watched the trial. I don't watch it consistently because I just don't have time to do that. Everybody is not IS where you can go down there and get in your car at 6 a.m. so you can be there on time and sit up in the courtroom all day. But the times that I've watched it, I have noticed that she's done that. She's not the only one that's done that. The other Miss Hilton, I think is her name, I've seen her do that as well. Queen Black says she always forgets to mute her mic. You said Love is trying any way she can to get the media out that admonished her yesterday for maybe being sneaky. Well, she's done some things, and the judge was like, I don't know if you're unorganized, or, I mean, I don't even know. Like, the judge seems frustrated, but she's not frustrated to end the trial. I mean, she seems very determined to finish this to the end. So I think she's done things where she hasn't turned over information. All of that stuff is foul. Like, you're not supposed to do that. And she knows that. And then the judge sent them to some Brady courses. They went to some training or something. Like, they've done everything to try to, everything short of a mistrial. So yeah, I get it. You guys are over it. You guys are over it. And you want, and she's done some things where I can see that you err on the side of it's probably something fishy when you see the key because of her track record, because of her history. This is why it was the assumption that it was something sneaky going on. A lady, Shell, said they are speaking on the witness today. Her identity was shown due to Zoom. Is this the lady that's on First 48? Because I knew that wasn't. I just saw on Twitter that was an argument as well, that she didn't want her face shown. Judge Whitaker said, we're not going to show her face. And the argument was, but she on First 48 and everybody know her. So what's the problem? It's a lot going on. Thank you, LaVersa, for the Cash App. You are so dope. Thank you so much. I appreciate the love. You said, yes, Detective Gaither. That's her name. I watch First 48. I'm an avid First 48 watcher. But she didn't want to. And she's retired, I think, now, though. Oh, Starfish said, no, this just happened about 10 minutes ago. Someone posted a pic of Detective Gaither and Miss Love. I can't. AK said her pictures are all over the internet. All you have to do is Google her name. Yeah, she's not. A lot of times people do gang squad and they do it undercover. That's not what she is. We saw her on First 48. So that's usually when you have someone that's in the gang squad, they don't show their face. And she is a part of gang squad. So maybe that was their point. But everybody know who the heck she is. Like, she's not using an alias. When we watched the YNW Melly trial, it was a big thing, and the guy came in and he had a ski mask on because apparently he does undercover work and he actually communicates and assembles and, congregates with actual gang members. And so he was trying to protect his identity. Thank you, Lisa, for the Cash App. You are so kind. But yeah, so I wasn't understanding this. It's just always something with this case. That's all I'm gonna say. It's always something with this case. Love said it's due to her new job. But they used her name though. Like, at least make up a name. Wouldn't that be smart? Don't call her Detective Gaither. Call her something else. Then we wouldn't have had no clue who she was. But if you gave her name up, we can Google it. So that was dumb to me. Like, that makes no sense. Miss V, thank you so much for the super chat. She said, thanks for your hard work, Pam. Blessings to you and the intellects. We appreciate it. You guys, please make sure you hit the like button on your way in. Jennifer said, Gaither is mixed up in the game. It sounds like that probably has more to do with her hiding. Well, Gaither needs to use Jones or something. Like, let's just use our common sense here. If you don't want your identity out here, but you've been on First 48, We can Google your name and 100 pictures show up. You probably got a Wikipedia. I'm probably exaggerating right now, but I'm just saying. You're probably all over Facebook. You're probably on Instagram, probably up there dancing with your badge on TikTok with some TikTok challenge, and got Detective Gaither all on you, because the picture I saw had it on her shirt. And then you get on there and say, my name is Detective Gaither, but I don't want my face out here. At least say your name is, make up a name. Say Boxenberg or something. Detective Boxenberg. Go by Detective B, Detective G, like something. Am I missing something here? Because I'm just using common sense. This don't have nothing to do with my degree. Like, what am I missing here? Lisa, I'm sorry, Lisa. I'm sorry. That was just the first name came to mind. She's like, don't put me in it. Don't put my family tree in this. She don't need to use my name either. Early Morning Vibe says she must want to be known, obviously. Well, she said she don't want to be. That's what she said today. I think, honestly, though, this is my opinion. I think because so many people on Twitter, Thug has so much support. You have people that have made pages specifically for putting clips out there, bloopers, when Miss Love gets in trouble. All of that stuff ends up, because I watch clips more than I watch the entire hearing or the entire trial for the day. So I think she just doesn't want to be a part of any clips. You know what I'm saying? I mean, her voice still can, because obviously usually they'll like record your hands or something, but she probably just doesn't want to be a part of y'all, because some of y'all are mean. She don't want to be a part of a meme because she's on the stand. Or like that detective yesterday, that one of those defense attorneys had him up there stuttering. He was like, and then that clip went around. You know what I'm saying? With his face. So maybe she doesn't want her face attached to y'all meanies out here that's gonna make some type of a clip. She's gonna mess around and be a part of a TikTok challenge because of something she said or how she was moving or something. Because otherwise it doesn't make sense. They used your real name and you've been on First 48. That makes no sense to me. Yeah, Woody, man, he became a sensation. He became an internet sensation, and you were supposed to be one of the star witnesses against YSL. She was disguising her voice today. Man, if y'all don't cut it out, are y'all serious? Like they had her, she was sounding like, my name is Detective Gaither. She had like a little voice sounding system or something to try to, yeah, I can't. I'm not doing this with y'all. I came here to talk about Ernest Williams, and we done talked about everybody but this man right now. We've been on for 30 minutes. Miss V said, don't want to look like a clown. Yeah. Because you got people. Look at 504. You got people. Just imagine, you know how 504 act. And you know we love 504 over here. But you know how she acts. And can you imagine like 30,000 of her with clips of you from you flubbing in court? That would just suck. When Nesto asked the police to get his and that phone was in the black bag and the police saw something they thought suspicious, would that be cause for search warrant and the dog? Let me get to this motion, because now you just let me know I'm taking too long. Okay, that's what you like. I'm gonna need you to get to this motion, Pam. That's what you're here for. All right, I got you. I can read the room. Motion to suppress vehicle search. Comes now defendant Ernest Williams by and through undersigned counsel and hereby files this motion to suppress vehicle search, any and all evidence obtained from the search of the white Ford F-350. You guys know that was in Shirley's name, but she did not drive it. And all derivative evidence. So that's all the evidence that was found inside and anything. So say, for instance, you get evidence out of the truck and then it leads to more evidence. So that's what derivative evidence, because sometimes you can get direct evidence within something, but then you're like, okay, this leads me to something else. This leads me to a name. Then that name leads me to something else. Then that something else leads to something else. So we want anything that came from this origination, we want all of that to be suppressed. Pursuant to the 4th, 5th, and 14th Amendments to the Constitution of the United States, Article 1, Section 1, Paragraph 1, due process, Paragraph 13, search and seizure, Paragraph 16, self-incrimination of the Constitution of the State of Georgia, that is OCGA, Section 17-5-30, and Section 17-4-20, and other statutory and case law. In support of this motion to suppress, Mr. Williams shows as follows. You guys ready to get into these facts? Because some of you guys were just jumping ahead of me. Like, what is the conclusion of this? Number one, the first paragraph provides Mr. Williams is charged in the indictment with the offenses of violation of the Georgia RICO Act, false swearing, filing false documents, bigamy, theft by taking, conspiracy to commit unauthorized practice of law, filing false documents, identity fraud, and deposit account fraud. Mr. Williams has pled not guilty to said charges and is presumed innocent. Paragraph 2. On or about July 7, 2022, law enforcement officer Natalie Fields and law enforcement officer Yvonne Yavatashenko, I probably messed your name up, I apologize, with the Roswell Police Department observed Mr. Williams driving his wife's white Ford F-350 eastbound on Pine Grove Road. Law enforcement officers observed Mr. Williams pull into and park the white F-350 at 1070 on Alpharetta Highway. Mr. Williams then exited the vehicle and began to take pictures of a for lease sign. So he was just there. He was like, shoot, because he like got evicted from his barber shop or whatever. So maybe he was there like, I gotta find me a new spot. That says it's for lease. Let me look. Take the pictures. Mr. Williams was subsequently arrested. So as soon as he got out the car and was like, choo, 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 they was like, shoot. And they had the lights on as soon as while he was out there taking the pictures. This is according to their factual basis. Mr. Williams was subsequently arrested in said parking lot on a warrant, EW0328723 out of Roswell, for theft by deception and searched without incident. So they were like, spread him. Make sure he ain't have nothing on him. After his arrest, Mr. Williams was notified by Detective Gooden that the white Ford F-350 would be impounded, and Officer Fields had the vehicle towed to the Roswell Police Department lots. On or about, so this was on July 7th of 2022. So on paragraph 3, we're on the next day. On or about July 8th of 2022, Detective Gordon contacted Roswell Police Officer Corey Duvall to conduct an open air sniff with his drug sniffing canine named Ivar on the white Ford F-350 that was driven by Mr. Williams. In her report, Officer Fields documented that Ivar positively alerted on the white F-350 for the presence of illegal narcotics. Because of Ivar's alert, Officer Fields obtained search warrant number SW030244 for a white Ford F-350. It has the tag number and the VIN number and all of that, and it was registered to Miss Shirley Strawberry. Said search warrant was signed by the Honorable Judge Debbie Ann Rickman on July 8th of 2022 at 2:44 p.m. During the search, multiple items were seized by officers to include a black book bag with multiple documents, a silver and black G-Tech computer, a gold iPhone, and a scan disk, 32 gigabyte USB drive, and keys to vehicles. The search of the white Ford F-350 was illegal, as said search was done without the issuance of a valid search warrant, without exigent circumstances, and after the vehicle was illegally impounded. In Georgia, case law related to impoundment of legally parked vehicles stems from the Fourth Amendment jurisprudence. Oh, Jesus. Okay, so I'm going to add a little bit of information to this. When I went to one of the hearings, I went to the preliminary examination and I saw Officer Fields, and what she testified to was that she had actually been following Mr. Williams for a while. And it had been, I don't know, 30 days, I think, maybe a little less than that. She had been following him anyway. And part of that, as you guys know, if you follow this, had to do with these leased premises on Pine Grove, where you had Erica King, who was the co-conspirator who pled already, on one house, and then you had Ernest in the other house. The landlord was suspicious because they were saying like all these cars is parked in a driveway. They had bounce checks. They hadn't paid their rent. They never really met them because allegedly, I guess they were saying Erica, who had a name Candy, was like the liaison and said that, oh, my client is a celebrity, so I handle all their business. But yet and still, when it came to the rent, they were bounce checks. And there's a lease that had Shirley's daughter's name on. It was just a bunch of stuff. So because this man came in and he was suspicious about who was staying in his property, there was an ongoing investigation, I guess, on him. So they were following. What Miss Fields testified to was that even though they knew that this car was Shirley's vehicle, that it was in Shirley's name, he drove it. He was the one that drove this vehicle all the time. So it was almost like an implied ownership because she didn't drive the vehicle. It was just in her name. And we know that from the cause, because in the cause, she didn't like the car. Like, she was trying to get rid of it. She was like, I don't like that big truck. And she wanted something different. He had just bought her, what did he buy her? Was it what kind of truck did she have? Y'all help me out. What kind of truck did she have that he bought her? So Georgia don't know incident to arrest. E Boogie 713. Thank you for the super chat. It was a G-Wagon. Thank you so much. That was not even at the tip of my tongue. I was thinking Benz, Bentleys. I was thinking everything but a G-Wagon. Okay. To say a G-Wagon. Well, I guess that is a Benz. But anyways. So she was driving that because he had just bought it or whatnot. So she testified that she knew that anything that was in there, and she was told that Mr. Williams keeps a lot of his stuff by these victims that would be evidence of his crimes in this truck. So all of this stuff was information that was there. So I'm going to assume that's why it was impounded. And typically when you impound a car, you can do what's called an inventory search. And they do a whole list of everything that's in there, and they'll like document what's in the vehicle. But of course, you can't go inside of stuff unless you get the proper warrant and all of that. And I guess that's why perhaps it was, I know at some point, she also testified that he wanted to get his medication or something. You guys help me with my memory now. It's been a lot. He like, before he was arrested, he actually went and opened up his backpack and there was medication that was in there. And so he wanted to get some medication or something of some sort, if I recall correctly. That could have been a reason why they were like, Is this legal medication? Is this illegal medication? I don't know. I'm just speculating right now. I'm just thinking out loud because I'm reading it for the first time. So you said correct. Okay, thank you so much. Let's go on into this document. So they say that the search was illegal. They said the police may not use an impoundment or inventory as a medium to search for contraband. Duncombe v. State, 138 Georgia Ave, 1976. The individual's right of privacy is superior to the power of police to impound a vehicle unnecessarily. Stobart v. State. Impoundment of a vehicle is valid only if there is some necessity for the police to take charge of the property. So basically, they're saying the car should have never been impounded. You should have called someone because you knew that Miss Shirley Strawberry owned it. It wasn't him. You could have let him call someone, offered for him to call someone because impoundment wasn't necessary. On the flip side, based on what I heard at the preliminary examination, I think the argument would be, well, we know, even though her name was on it, you're the owner. So because you're the owner, this is why we did what we did. But I'm just speculating based on the information that I received sitting there at that preliminary examination. In each instance, the ultimate test for the validity of the police's conduct is whether, under the circumstances then confronting the police, their conduct was reasonable within the meaning of the Fourth Amendment. Georgia courts have found impoundment of a car authorized where the sole occupant was arrested for driving with the suspended or invalid license, and he had no companion or other person capable of removing the car in a timely manner. And that's Pierce v. State, a 1990 case. And they have Gooden v. State, which is a 90 case. There, where all the occupants of the car were arrested, then that was a reason for impoundment. That was in Evans v. State, where the arresting officer testified he would have permitted a reasonable request for alternate disposition of the car, but the defendant made no such request. Williams v. State, where a lawful custodial arrest of the car's sole occupant rendered reasonable the search of the passenger compartment, both as a contemporaneous incident of the arrest and as a routine inventory of the content, where the car did not bear a valid tag. So they're giving you all the reasons where impound is proper. And where the car was parked at a business and the owner of the business requested that it be removed. That's in Fitzgerald v. State. Furthermore, the Court of Appeals has adopted the view that when a driver is arrested and a reliable friend is present who may be authorized and capable of removing the vehicle, or where the arrestee expresses some preference for a private towing service, the rationale for impoundment does not exist. I don't see where that's really applicable because he was by himself. There was nobody present. And I guess maybe he's going to argue, perhaps on the body cam, that he asked them, hey, can I call my wife to come get this car? Or can I call my buddy, my best friend of over 30 years? Can I call my best friend from over 30 years and tell him, could he get this car? So maybe they got that on a body cam or something, perhaps. Moreover, in Mitchell v. State, the court held that there was no showing that impoundment of appellant's car was reasonably necessary after noting that, quote, there was no evidence of any connection between the car and appellant's arrest. No evidence that the car was illegally parked or was hazard to traffic, or that appellant was consulted regarding alternative dispositions of the vehicle. So with that case law, I bring you back to the preliminary examination where detective, and I'm just going to use the case law that they're citing, is supposed to be a relevant reason. When the detective Fields was on the stand at the exam, she basically said that she was advised, she knew because she followed him, that he was the only one that was really driving his vehicle and this was his car. But he also said that victims let her know that victims let him know that a lot of his personal stuff, the stuff that would show the crimes that they are alleging, was in that car, whether it be on that computer, or whatever, that he keeps a lot of the stuff that shows the alleged crimes close to him, is what one of the victims alleged, according to Miss Fields' testimony. So that would kind of, wipe that argument out right there. But there is nothing in the warrants or police reports that authorize law enforcement officer Fields to impound the white Ford F-350. First, there is no evidence of any connection between the white Ford F-350 and Mr. Williams' arrest. Well, I just told you what the alleged people said to Miss Fields, according to Officer Fields. So there's that. Law enforcement officer Fields arrested Mr. Williams pursuant to an arrest warrant out of Roswell for theft by deception. Officer Fields even memorialized in her search warrant for the vehicle that the white Ford F-350 is registered to Shirley Clark Strawberry and not Mr. Williams. Mr. Williams was not arrested due to a driving violation, and there's nothing that suggests the white Ford F-350's tag, insurance, or registration were invalid at the time of the arrest. Second, this is the second reason why they're saying Mr. Williams was never given the opportunity to call a legal, capable driver to move the vehicle in a timely manner, and he was also not given the opportunity to request a private tow. What does he was not given an opportunity? Were they supposed to ask him? Is that the law? Or is he supposed to voice that? Nonetheless, we're going to move on. Third, there is no issue of whether the arrest of Mr. Williams rendered reasonable the search of the passenger compartment, both as a contemporaneous incident of the arrest and as routine inventory of its content. Mr. Williams was arrested outside of the legally parked vehicle and searched without incident. Officers made the decision to impound the vehicle, then requested a drug sniffing dog once the vehicle was impounded in police custody a day after the arrest. Only afterwards did officer gets a search warrant to search the vehicle, approximately 24 hours after Mr. Williams was arrested. Fourth, the owner of the location where the white Ford F-350 was parked did not request that it be moved. In short, there was no showing that the impoundment of the car was reasonably necessary at all. So a lot of these arguments were already, like I said, the reason why I'm able to answer and respond to how I think Officer Fields will respond is probably more to it, was because if you guys watch that preliminary examination, which is a probable cause hearing, because all you need, the lowest bar we have is probable cause. That literally means a crime was committed and I say you did it. So if I say I saw you rob somebody, listen, I saw Peter rob this person over here. That's a crime. I say you did it. What does Peter have on? Red shirt, black pants, over there at the defense table. That's probable cause. Now, whether you have enough evidence to convict someone beyond a reasonable doubt is a whole nother bar. So probable cause, just like they say that about indictments, they say they'll indict a ham sandwich. That's like the joke that, that you'll hear out there. It's such a low bar. Now, whether you can carry your burden at trial, that's why you have a lot of prosecutors that may opt not to pursue the case because they don't just go by probable cause. They know that's easy. A lot of them will say, we want a high probability that we can win at trial. So they'll look at the totality of the case and see if there's a high probability, but they only need probable cause in order to actually arrest you and charge you with the crime. But let's go on. Let's go to this. Because the impoundment, let me see if you guys have any questions, because I get caught up in reading this stuff and you guys are just seeing how I analyze and go through my process because I just read it for the first time as well. You said child Peter be robbing Paul. I don't know why this stuff is gone. Maybe I need some more rest. I know my examples are not exempling today. I know. She said motion denied. Where's my gavel? I'm just recalling a lot of this stuff came up in the exam. So I pretty much know for some of these responses, and it's probably more to it, that what Detective Fields is going to say, but I just remember this is what's coming to my memory on what she testified to at the examination. LC said bigamy alone would get him 10 years. So you got to take this. The biggest charge is RICO though. So I get it. We're going to try to chop away at RICO because everything will be fruit of the poison. So that's like a domino effect. If I can get this search warrant suppressed, if I can say you should have never impounded my car, that means my car should never have been there for you to even request some dogs to come sniff. That means once the dog sniffed and got a hit, then you wouldn't have had the probable cause to get the warrant that the judge signed to search my car. That means once you got permission to go inside my phone. All of this stuff is a domino effect. You have to start from the root, and then all of this is going to be knocked out. So the biggest charge is the RICO. So I see with the bigamy charge, that's going to be a little rough, like it kind of documents say what they say. But RICO, you see what YSL is going through. They try to put you there. They try to put you down with a RICO. Yeah, we really got, I'm going to need you guys to hit that like button, as Lisa said, because we have well over 1,000 in here. And, that's it. It's free. Gets me in the algorithm so we can get more people over here that know we're over here. I am a traveling YouTuber. I'm over here in the courts trying to give you guys firsthand information so we can have these discussions and better analyze these type of pleadings, because had I not been to the preliminary exam, I wouldn't even know what their argument may be. You know what I'm saying? So show your appreciation. Just hit that like, subscribe to the channel. That would be cool. I really appreciate that. You said, I can't wait to see his interrogation interview. And that was another thing. When we saw the discovery list, I'm like, didn't they say he didn't give an interview? But apparently there's interviews. We know that Erica King did not play. Okay. She didn't pretend like she wasn't saying nothing. Erica King was in there like, what do you want to know? Me. How long did you know him? 20 years. Where did you know him from? From the church. What church was it? Mount Beulah Baptist Church. Okay, I'm making that name up. How did you know him? I knew him through this person. I was his assistant. He was married to Shirley Strawberry. We went on double dates. He told me to do it. Your Honor, I'm guilty. Please just give me as much leniency as possible. I don't want to do time. They had me eating up out of a soap dish with my cereal. She was in there singing like a mug. Okay. Let's go. Let me remind you guys real quick that you guys need to hit this.
And another thing you notice, the first thing they say, make sure you guys hit that like and the subscribe button. That's what it's all about. After they get them dogging you out of before they dog you out, that's the first thing they say. If you like this video, make sure you hit.
You have 1 minute remaining.
Let's get back here to this argument. Now, I know you guys have hit that like button, and I appreciate it. Because the impoundment of the white Ford F-350 was illegal, all subsequent actions taken by law enforcement officers the following day were also unlawful. The Fourth Amendment guarantees, quote, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. The ultimate test for the validity of the police's conduct is whether, under the circumstances then confronting the police, their conduct was reasonable within the meaning of the Fourth Amendment. And that is in Wren v. United States 517. That's a U.S. Supreme Court case. That is the highest law of the land. 806, 1996. There is nothing in the warrant or police report that justifies a search as an inventory pursuant to an impoundment of the vehicle. Furthermore, there is no reasonable suspicion or probable cause to believe Mr. Williams was engaged in illegal drug activities, which required the need to request a drug sniffing dog a day after his arrest. Now, the issue that I think they will also, again, I believe he asked for medication, and also there was some type of I don't know when they found the liquid V, so I'm not gonna say that had anything to do with it, because they may not have even known that till they were able to go inside of the bag. But he actually allowed them to open it. I think either he allowed them to open the bag and look in it to get whatever he needed out of it, or maybe they brought him the bag, but it was clearly like medication. So be very interesting how they argue this point. As stated above, Mr. Williams was arrested on warrant EW 0328723 out of Roswell for theft by deception on or about July 7th, 2022, while driving his wife's white Ford F-350. So I think they're saying it away as if she was really like driving this truck. But again, Officer Fields said, no, we followed him for a while and she did not drive. This was his vehicle. It was in her name, but it was his vehicle. Officers observed Mr. Williams pull into and park the white F-350 on Alpharetta Highway, then exit the vehicle and take pictures of a for lease sign. Mr. Williams was subsequently arrested and searched without incident and in said parking lot. Afterwards, officers illegally impounded the white Ford F-350 and had the vehicle towed to the Roswell Police Department lot. At no time did any officer memorialize they smelled any type of illegal narcotics coming from Mr. Williams or the white Ford F-350 during his arrest. But see, if they would have actually smelled it while they were there, they may have been able to still get a warrant based on that. They wouldn't even need a dog. You can get a warrant based on a smell as well. If you're there and you smell marijuana coming out the car, that is a way to search the car. They wouldn't even needed a warrant for that. But sorry, guys. Why the cable like that? Okay, let's go. At no time did any officer say they found any type of illegal narcotic on Mr. Williams' person or in the back of the police vehicle which transported him. At no time did any officer memorialize they saw in plain view, because you can do a plain view site. So like if an officer is looking in your car and they just see you got a bag of something sitting there, that's a reason that they can search your car as well, based on plain view. Anything in the white Ford F-350 that looked like illegal narcotics. Also, Mr. Williams' arrest was not premised on him engaging in illegal narcotic activity. On the following day after his arrest, when the white Ford F-350 was illegally in police custody, at no time did any officer memorialize they smelled any type of illegal narcotics coming from the vehicle or that they saw in plain view anything in the that looked like illegal narcotics. Even with a complete lack of reasonable suspicion or probable cause to believe illegal narcotics were present in the vehicle, Detective Gordon contacted Roswell Police Officer Corey Dovell to conduct an open air sniff with the drug sniffing canine on the white Ford F-350. In her report, Officer Fields then documented that the canine positively alerted on the white F-350, which was the basis for her to obtain a search warrant. During the search, multiple items were seized by officers to include a black book bag with multiple documents, a silver and black computer, a gold iPhone, a SanDisk 32 GB USB drive, and keys to vehicles. Because the impoundment of the white Ford F-350 was unlawful, the subsequent canine air sniff and search conducted on the vehicle was in violation of Mr. Williams' Fourth Amendment constitutional right as well. In summary, Georgia courts generally view the impoundment of a legally parked vehicle as unreasonable unless there is a specific justification for the vehicle to be impounded. If the vehicle is legally parked and poses no threat or danger, impoundment violates the Fourth Amendment protection against unreasonable seizures. The ultimate test for the validity of law enforcement conduct is whether, under the circumstances then confronting them, their conduct was reasonable within the meaning of the Fourth Amendment. The search of the white Ford F-350 was illegal, as said search was done without the issuance of a valid search warrant, without exigent circumstances, and after the vehicle was illegally impounded. So exigent circumstances is like an emergency situation. Wherefore, defendant respectfully prays that this honorable court set this matter down for a hearing, and upon consideration of same, exclude from evidence any and all evidence purportedly seized in conjunction with the instant illegal and violative search and seizure, including but not limited to any derivative evidence obtained as a result of the search. And that is from Brother Counsel Sean Hoover, who has written this request to the court over there in Fulton County. So I'm going to see what you guys think. I think, like I said, I am all for zealous advocacy. I just can go off of what I've seen in the preliminary examination. I don't have both sides. You know what I'm saying? I don't have all of the information. So everything that I'm saying is just speculative based off the information from this document on what I think they would probably argue. But I'm sure they got their own stuff. And perhaps, Mr. Williams is right. Maybe they shouldn't have maybe they just tried to do the sniff as a rationale to go into his car. Maybe they can say somehow something was planted in order for the dog to smell it like he smelled it, just to get into his car, because they really didn't have a reason to go into his car. I could see you being a little suspicious about it, but I think the argument for impoundment is going to be that even though Shirley Strawberry's name was on it, this was your car, and we had victims of which said that you keep your stuff in this car. And so they try to do the inventory search. And then once you ask for certain, may have asked for, I'm just speculating on the medication. I don't know if that's the reasoning. You know what I'm saying? But I think that his attorney is this is what you should do. So shout out to you, Mr. Hoover. I know you don't really care for us, but I try to be fair. Like I would have tried to file something too. I said it before. I was like, I would file a motion to suppress it to make your job easier. You get some of this stuff kicked out, then you can just deal. You like, with the bigamy, they probably ain't did that. They had to dust off the books for that one. Like, when is the last time they really convicted somebody of bigamy? RICO is a big charge with some big consequences. So let me see what y'all talking about. Dr. Miss Piggy Braxton said if Nesto had people in that truck that smoked weed, the smell could have been picked up by the dog. Okay. See, y'all so smart over here. That's true. That is a very true statement. But why did they feel like so what they're arguing on the flip side is that when they went, they never said we're going to impound this car. They never wrote it down and said we smelled marijuana on the plain smell test. In theory, they could really like search based off of that or try to request a search warrant. But that was never documented is what the argument is. They never documented that they smell anything. So why all of a sudden once it's impounded, you say, well, we need to get a sniff dog. That's what they're saying. There was no reason for you guys to even get a dog to come sniff in the first place. But we first want to get to the point of you probably shouldn't have never impounded is what their argument is. You should have never impounded. Then when you impound it, you make up a reasoning as to why you think we should get a sniff dog. Then the dog just so happened to get a hit, and now you got all these warrants. He hasn't, his issues or what the allegations are has to do with financial crimes. It has nothing to do with drugs. So, Kelly said that is strange. They never documented that. Yeah. Amy said if you were his attorney, he would probably be out like by now. Man, I probably would have been. I had a problem in the beginning, and you guys know. And see, the thing is for me, like people say with Diddy. I don't care for Diddy as a person because I heard things back. I done said this 100 times. I haven't really cared for him since the cheesecake. When he had those people walking to go get cheesecake, and a couple of them were from Detroit. Sarah was from Detroit. Rob, I know from Day 26 was from Detroit. Like so a lot of them, that went on there were from Detroit. I know it was a few seasons. I don't think they were on the same ones. But nonetheless, I had a problem with that. I just felt like it was the air. He got into it with the and we're talking about Diddy. He got into it with what is her name? Gibson. She was the choreographer. He was treating her like trash. So I ain't like that. But I do feel like he still deserved a zealous advocate. I felt like his attorney, he was making arguments like, huh? Then you do an entire interview on TMZ that is on Tubi. And then you get a question when I seen that clip about the baby oil, and you say, you just saying things at the top of your head. And then, so it made me look him up, right? So there was a guy, and I can't think of his name, but he was accused of ex trafficking as well, along with some other crimes. He had like some type of a cult, and it was over there in New York. This same guy represented Diddy's attorney, represented this guy that was accused of the same thing. He was saying a lot of the same sound bites. Like when he came out, he would say, this was all consensual. These are grown, these are adults. We're getting into a situation where now we're getting into people's bedrooms. That's dangerous. That man got 108 years in prison. This is Diddy's attorney, and he's kind of saying the same little clips and sound bites. So even though I can separate the emotions of something and I can look at something with critical thinking and say, or, like from my legal pros, like I do that. Like I can separate and I can see your flaws and I can see your weaknesses. I don't look at it like I don't like you as a person. I ain't with you. I ain't sleeping with you. I don't care. You know what I'm saying? But I can say, like, you're a foul person. I don't really like you, but you do deserve zealous advocacy. I said that about Nesta. I just think it's weird to me that they hold you in in jail, and especially on Rice Street. They just got a DOJ. It's like 90 something pages of how it's inhumane in that facility. So you guys hold people, the dangers within that facility, people getting stabbed, people, like, just imagine you're in there for a petty theft for like $100, but you don't have $100 to pay. So you're in there, basically you stay in there until you keep every 90 days, you get a bail hearing, and then they usually reduce it until dang near you're on your own recognizance almost. So you do a whole year trying to get your $2,000 bail down to whatever, because you can't afford it, but you end up leaving this earth because you can't afford bond because of the inhumane conditions there. That's still wild to me. I don't care who it is. I mean, that's just what it is. So when all of this happened and I wasn't as familiar with the Georgia system, I was asking my, people that I knew, like, so they could just hold you and you unindicted, like they can just hold you and that's that. Like, you don't go through the whole system. They can just keep you in court. And then the only thing you have is every 90 days, you're trying to get a lower bond. That's it. Now, I know that you can do motions to dismiss pre-indictment if you have had the facts for it or whatever. You think that they haven't presented enough evidence to hold you, but for the most part, you're sitting there, and I just think it's jacked up. And I think the DOJ is looking into Fulton County as well. So I can totally separate the two. And I think some people just get really emotional about this, and you can't be emotional about it. Okay, you ain't got to hang out with him. He doesn't have to come to your Thanksgiving dinner. You don't have to take him to brunch. You don't have to do any of that. But, just look at things like, that is a little suspicious. That is a little, we have to be open-minded about it. I think a lot of us was just more mad at, at like some of the stuff that was being said by his good friend, running these YouTube streets, and some of the things that were being said. But Wooten is prepared to answer the motion. I'm sure Wooten is. I'm sure. And we'll have his response, and we'll go over that as well. So, That girl says, so the only defense officer feels have is the victim said the evidence might be in the truck. No, I don't know. I was very clear. They have not responded. I don't know what their response is going to be. I was just trying to relay what I remember some of her answers were when they were asking her these questions in the preliminary examination. That's all. They may have something stronger as to their reasoning. They may have found a little weed roach or something, and I don't know. They could have found a pill at the bottom of the car. I don't know what they found. I don't know what their rationale is, but we'll know that in the response. I was just speaking generally of what some of these questions, when they were asked, what some of the responses were in the exam. Does Wooten have to respond to a motion within a certain time period? Yep. Usually when the judge gives you a hearing date, then you say, okay, well, I'm going to respond. So like here, when we do motions, you have to give like 28 days before you have a hearing, depending on what motion it is. And then depending on what motion it is, you have some that have to respond 14 days before the hearing, or some people have to respond 7 days before the hearing. So it just depends. You notice with the gag order, that was filed a couple of 2-3 months ago or something, and there was no movement. And then when the court set it for hearing for September 16th, then we saw Wooten's response a few weeks before the hearing. So yeah, usually it's a certain amount of days prior to the hearing is when it's due. That was a great question. Starfish said if they were following him, getting the car was easy way to get into his stuff. That's true. Jay Vicker said Hoover, aka Motion King, singing slow motion for me. Now, ooh, I like it like that. That's slow motion. Jazzy, thank you for the super chat. You are so generous. You said if Nesto and Cuff Diddy are convicted, do they only have to serve half of their sentence to be eligible for parole, or is there a minimum? Please give us an example. So a lot of times when people talk about how many years you're going to do, they look at the statutory maximum. So they'll say, like with Adams, they were like, he's facing up to 45 years. Okay, in theory you are, but you have what's called sentencing guidelines. So from a federal standpoint, you have a PSR report. They go through all of that. Then you got numbers, the numbers add up. Then in federal courts, you got variables. It's a whole lot. So it's like, have you been convicted in the past? That's 2 points, if not 0. Have you done this in the past? Do you have any type of mitigating factor? So it's like points. So you're not going to just automatically go to the top. So then you have a range, and that range might be 5 to 10 or whatever after they do all of the assessment within your sentencing guidelines. So then you have that range. And then within that range, of course, as the attorney for the defense, I'm going to say, we need to go below the guidelines. The guidelines are just a suggestion, Your Honor. My client is the best ever. He has never really committed a crime. He is a family man. He got 6 kids. He works at Ford. He's more beneficial outside. His mom is sick. He takes care of his mom. We don't want him gone away from his family. That's his sole provider. Whatever your reasoning is. So, Your Honor, we think we got mitigating factors that this is just a suggestion, but can you please go below the guidelines? And sometimes you can pull it off. But if not, you want them to go to the lower end of the guidelines. Of course, the prosecution, unless you guys have some type of agreement, they usually going for the gusto. If they don't like your client, they want to go to the higher end of the guidelines. And so the judge ultimately makes that decision on what your sentencing is. And when they make that decision, they'll tell you when. Sometimes they'll give you a range, and then the lower amount is usually the time of which you are eligible for parole. But of course, you have some such as felony murder where you ain't getting no parole. You're never eligible. Like you get life without the possibility of parole. Then you have some where, of course, you do get parole, and then there's a certain date. And then after that, every certain amount of years, you go before the parole board. So it may be every 5 years. So if you're denied, you have your earliest eligible date of parole is 10 years. You go before the parole board. They tell you, you've been running amok up in these prisons. So we think that the society that you're going to be a hazard to the community, that it would be unsafe if you got released based on your records and what you've done. So things that you do in prison also can affect whether you get out or not. So no, you ain't in here getting all the degrees and certifications and like everybody else. You in here running the whole muck. So we think that you need to, we're flopping. You go back. No, we're not going to grant your parole. So you got to go back. And then after like 5 years, you go back and you can keep going back after a certain number of years in order to go before the parole board. Like, can I get it now? Can I please get it now? What about now? So that's kind of how that works, generally speaking. You said, Miss HLS said, if I'm the judge, you do the crime, you do the time. You have to have some grace and mercy. There are some people that all they need is a starter case, and they like, I'm not about this life. I spent 24 hours on a concrete floor. I had a dry ham sandwich for Thanksgiving. I don't want to go back. But then you have people, I've met people in prison that have said, if it wasn't for prison and me doing some time, I would have been in here for life. So it actually may have saved my life that I went to prison. So you have to know kind of the balance. There are some kids that just get caught up in the game. And I don't think, that's why we have a lot of diversion programs, of which they'll give you certain criterias. If you do community service, if you have a drinking problem, or if you have domestic violence, you go to those classes, and then we'll expunge your record at the end as if it never happened. I think people deserve, especially when you're younger, you do dumb stuff. And so I think you deserve a second chance. But you do have people that are straight prosecutor minds, and they feel like if you did it, I don't care, you need to go to prison, period, point blank. There are a lot of people that are like that. But unfortunately, it didn't happen to their family, or fortunately, I should say. They haven't experienced the system. And I think that if it actually happened to someone close to them, or someone they knew, they would have more grace and mercy. Because if it's your kid, you want them to have a second chance. Some people do flub up and they mess up. Then you got some people that are just repeat offenders, and they're just straight criminals. They're going to do that. They want the fast money. They can't get away from it. That's just what it is. And they're habituals. That's why they call them habituals. You're going to do it over and over again. They need to be locked up. But you do have some people that just make mistakes. They do make mistakes. They wrong place, wrong time. They thought they wanted to be hard. Then they went to jail for a couple of days and was like, nah, I'm not about this life. So, it seems what they found in the truck may not even support things in the RICO. The computer is for CP. CP can be dropped, but all these discovery and witnesses seems like they don't even need the bag. And yeah, because you have witnesses that can testify against you. That is true. No, that's the truth. I think a lot of the stuff that was found. Now, there were numbers written down, like credit card numbers. Remember, you have one of the victims that's alleging that he used her credit card. Those numbers were written down or whatnot. But there are other ways, other evidence that perhaps you can corroborate it without even using that. That's some of that stuff. You're right. It'll just bolster that they have victims that are alleged victims that are coming forward saying certain things. But this certainly could be helpful. You know what I'm saying? Like it certainly would be helpful. The less evidence you have against you, you can get people to try to go against the credibility of that person. If it just becomes the credibility of a person without anything to corroborate their evidence, that's why, like when I did the Bishop Lamar Whitehead case, it was crazy because the federal government, they had corroboration for their corroboration. So they had Miss Pauline talk about everything that Whitehead had done to her, telephone conversations, text messages, and then they backed everything up with a text message, with phone records, with someone that does data locations with the cell towers. They like triple backed it up. So a lot of times corroborating evidence does, it helps you in your case. You don't want it to just rely on a he said, she said if you can help it. But I agree, especially when it comes to these crimes, it's probably people. He's going to probably argue that she said that he can do it. I couldn't. So this would help if the numbers were written down. Let's just think about this. If the numbers were written down, then that means that he had access to continuously use her information. Again, this is all allegation. If he did write the numbers down and they were found, then he can just use that number. Otherwise, he can argue, well, if she had to give me the credit card every time I used it. So how was I using her credit card without permission and she was giving it to me? We were friends, or we were in a relationship, or whatever the argument is. And so she let me do this. This was a gift. As a juror, how are you going to know the credibility of that? Whether she's just mad at him because they're not cool anymore, or she has buyer's remorse because now she sees that he's with other people and he ain't studying her like that, or he ghosted her or whatever. Then what if the juror looks at it like that and that's how he presents it? But if you got a piece of paper that got her name and credit card numbers on it, then you can use that as, hey, this is evidence that he had access to her stuff without her permission. So it's very beneficial to bolster your live witnesses. Sensible said he did not know them folks. Yeah, all right. I don't know about that, because didn't Sonia say these were women that he was in relationships with, allegedly? Yeah. I can't say nothing. Y'all asked me the question, and I'm giving you the answer. That's all I'm saying. I'm like, let's think about why stuff like that is important, because it was a valid point that that's not the only evidence they have is what they got in the truck. That is true. They have actual live witnesses, allegedly, that are saying this. Witnesses are evidence as well, but you have to have a credibility issue. So on cross-examination, my job, I'm going to try to come against your credibility. You were scorned, weren't you? You were just mad that on this day I went out with my wife and I didn't go out with you, but you knew he was married. You went out with him anyway. You thought that he was going to leave his wife, or whatever your cross-examination is going to be. You know what I'm saying? If you only got that, then maybe as a juror, I might have reasonable doubt. Yeah, it may have been a gift. It may not have been a gift. I may be like that. But if I got written documentation that you had access to my stuff and you weren't supposed to, then that will bolster it and corroborate what my witness is saying. Is all I'm saying. Dusty, thank you so much. You said, thanks, Pam. You're professional with compassion. You deserve unlimited blessings. I received that. Thank you so much for the super chat. Yeah, Kelly said, yeah, these phone calls are going to be major in this trial. Yeah, I think it is. I really do think they are. They can be utilized, and they use phone calls all the time. It's not a YouTube thing. They give you phone calls. I think, honestly, it's actually, I know they hate it, but it's actually beneficial to them in a way, because oftentimes what they'll do is it'll be the day or two before trial, sometimes a couple hours before trial. They'll come and give you, he's been in jail for 2 years. And that may be another reason why they kind of keep him in jail. Because the longer, not just him, I'm saying in general, in Fulton County, the longer you're in jail, you're gonna talk, right? Nobody's just, even though Nesto knows that people are listening to his phone calls, it's not stopping him from talking, because that's your communication to the outside world. So even though y'all not talking about nothing, you're not gonna not talk, because you know that people on the, for me, I would be like, write me a letter. We ain't talking no more. But it still hasn't stopped them from doing that. So I think a lot of people are like that. You're going to talk. You're going to say some things. They're using phone calls, I think, in YSL. You're going to talk. So that's another reason why they might try to keep you in there, so they can get you to be talking on these phone calls. But oftentimes, the prosecution will keep an eye on those phone calls, and then they don't give them to you till the last minute. So you got to go through all of these phone calls and stuff and not know what your client said that was dumb as hell until you're already in the crux of trial. So you should be prepared for trial. However, when you go through your first day, you don't just go home and eat and go to bed. You go home, you eat, and you start recapping for the day and whatever you're going to do the next day. That's how you prepare. But imagine that now you got 8 hours of phone calls that you got to go through all of these phone calls when you should be really preparing for the witnesses that are coming the next day. So that happens a lot. So even though I know they hate these phone calls, this may have been like, so at least you know what your client said that was done, or whoever was on the phone that was done. That's just my opinion. That's all I'm saying. But Pam, to read your mail too and your emails. Yeah, they do, but we don't read. Okay, so we don't read the actual letters. Like we don't have access to that. Those letters, like they read them, but then they give them to the inmate. That's not anything that we get from the public. What I'm saying is public access. FOIA allows you to get recorded phone calls. They allow you to get video calls. They allow you to get text messages on the pad. Anything electronic, you pretty much have access to. They do read like with the JPEGs. That's the email system. They do read those as well. But what do you have access to as the public? Starfish said, this is getting interesting. If the lawyer can get the impound and search thrown out, it's game on. Yeah, I'm not saying it's going to necessarily throw the whole case out, but does it weaken the case if he can get it thrown out? Yeah. Because again, you're going to get a jury pool. I think people automatically, like, for some reason, they think that everybody's on YouTube in the whole Fulton County, which isn't true. But you're going to get random people that never heard of him a day in their life, don't know anything about this man, because they're not going to want anybody else on the jury. They're not going to want anybody that heard about this case or know about him. And they're going to weed that out doing voir dire. And so you get just a random person that doesn't know him, doesn't know Shirley, don't know about the divorce, don't know about anything, haven't filed, don't know about Sonia, don't know about any of these people. And they look at the credibility of the person, and then they're able, if his attorney, if Mr. Hoover is able to successfully cross-examine these people and tear up their credibility, and you don't have anything else to corroborate what they're saying, it may actually, go the other way. That's all I'm saying when it comes to those specific charges. He said he let Boney tell one her mouth on the cause. And he was telling her a few times, like, shh, I'm not talking about, I ain't saying nothing. He like, I ain't saying nothing. And she just keep talking, well, this so. And we're going to, I'll do background checks on them. And I did this and I did that. And I'm going to do this and I'm going to do that. I was like, girl, are you serious right now? Like, I'm going to, and that person, they're out of town and their dad is, look, do you know their dad's background? Do you know that he did this and he did that? Do you know about this? Do you know about that? Do you know about this? And he just sitting there looking like, I ain't saying nothing. Okay. Now, what you got going on today? Let me see your nails. I like that color on you. He just tries to change the subject because she wasn't like picking up what he was putting down half the time. GC said, I think his interviews he had may hurt him. That'll be interesting too. We don't know about these interviews. What if in the interviews he may have acknowledged he knows these people? I think also it's going to be difficult. Remember, he has the unauthorized practice of law, of which Erica has pled to. So what the government did was they got a RICO and they got all of these different alleged crimes as overt acts, but then he also charged them separately with each of those alleged crimes as well. So, but the RICO, again, that's the biggest charge with the biggest time. So, his attorney's supposed to try to get that thrown out. I bet IS won't be there tomorrow. Well, if the last time, well, I wasn't there, but I know the last time Dana was there, and I believe when Dana's there, she's not supposed to be there anyway, because that became an issue the last time. So I don't know. I just go there and try to get my information for you guys and move on and try to stay away from all of that rigmarole, even though my name somehow ends up in it. I'm like, I was here taking notes, okay? I don't even know what you guys are talking about right now. I didn't even know it was a whole brawl. Sean Hoover should have submitted this motion 2 months ago. Why would you say that? He should have done it 2 months ago. What is your rationale? What if he just now like got most of the information and was able to go through it, like the discovery? Because he had terabytes worth of discovery, so I'm sure it took a while to go through it. Y'all so crazy talking about shoulder nails. Hit the like button, y'all. She said if his attorney is court appointed, they're going to use the semi-popularity of this case to put themselves on the map. They could. Yeah. Sometimes you do have those cases that elevate your career. That's what I think they were trying to do at YSL, but it's had the opposite effect. They might have jacked themselves up. But now the defense attorneys on YSL, they have some very, very, very good defense attorneys. I think law students should be required to watch the work of their defense attorneys because their defense attorneys are great. Let's see. Oh, wow. He's done phone calls with these alleged. Now, I do remember one of the phone calls where he was trying to get them to call. It may have been because of the alleged outcry statements and all of that on the SA case, that he was trying to get people to call his wife, his ex-wife, at one point. Like, you still talk to her, right? And all of that. So, yeah, they was trying to get people to talk. But yep, I will be there, Lord willing. Yeah. Is it rain outside? I don't know what that noise is. Yeah, the defense is awesome. They're very, very good. So court is supposed to be is scheduled for 9:30 in the morning. However, was it Wooten? I think it was Wooten had a conflict. And so he has something else tomorrow as well. So he was trying to do Ernest Williams last because it's going to be longer because they do have to respond. They're supposed to, I guess the judge is going to hear the response to the whole trying to dismiss the RICO. And it was a couple of other motions that were filed and the judge didn't give an opinion on it yet. So I think that that's going to go forward. And then whatever this plea trial situation is. But so I'm not sure if it's going to be later because the last time on September 16th, it was scheduled for 9:30 and it didn't happen till the afternoon. So, but that's what the schedule is. This has nothing to do. I mean, just because he filed this motion doesn't mean that it can't be heard. It's not going to be an actual trial tomorrow. I doubt that. I think that's what they call it, like a final plea or trial. He'll probably get a trial date tomorrow, I would guess. Jay Vicker said it's going to be a long day. The last one, Hoover, was hours late, and now tomorrow with double booking. Yeah. That's what it sounds like to me, that we're going to be there posted, and I'll probably be eating lunch over there at the court. I know I have a couple of attorney friends that work at the court. So maybe if they're actually there tomorrow, I can see people that I don't normally get to see that I went to law school with. Dusty said Pam stands on business, but she can still do the Nesto show. Thank you. So, yeah. You missed the start of the live. Did you have an opinion on the YSL judge and Miss Love? I did talk about YSL just a little bit. And I mean, I don't know. I think Miss Love is out of order a lot. That I do think, and I think the judge is allowing her to get away with a whole lot of stuff. She's putting on the whole theatrics of being pissed off and like, oh my God, I got to take a break for like 5 minutes so I can decide on this motion. They had everybody on the internet like, oh, this the big one. She might dismiss this case. She's gonna do it. Well, not this. She's gonna do a mistrial. Oh, she's gonna grant the mistrial. This is the big one. And then she just came back and was like, came up with some excuse, I guess, and then the trial kept going. But you know, I can see they put so much time and resources in this case. That would be such a waste to end up just stopping this whole trial. And then will Madam DA let this go, or will she still try to pursue it? Pam, are you coming back tonight to discuss? I may actually do that. It'll be later though, because I got to eat dinner and stuff. So it'll probably be like 10, 11 o'clock. But I'm going to come back. So all 1,200 of you guys, make sure you come back tonight. I'm going to try my best to come back tonight and talk about Mayor Adams and him saying basically he wants the government to be sanctioned on this leaked info. And I do think this is something that should be discussed because it's very interesting. I wondered, I'm like, how these people know what the government about to do before the people that's getting indicted know about it? I think that's very interesting. And that his attorneys have been seeking information and requesting an investigation into how this stuff is being leaked. So yeah. Thank you, PW. I appreciate it. I'm definitely gonna try my best. The food we had earlier was very good. Early morning vibes. We had, I don't know the name of this place, but we clearly, so we go in a place we probably should not because we had just came off the plane. So we go in there, we got on jogging pants and you know the relaxed plane gear. And everybody in there is like, I said, they were looking at us like, are they going to be able to pay for this meal or not? I think that's how they were dressed to the nine. Like, they were like, do you have a reservation? I'm like, I'm just hungry, man. I think they were looking at us like, McDonald's is down the street. Can you and your family go down the street to McDonald's? Because you guys don't belong here. But, they all came in there looking like, you know how the people that look real plain, but their plain clothes look like they paid $20,000 for a pair of pants, you know, $2,000 for the cuff link. Like that's how they were looking in there. Cannot think of the name of the place, but it was just, I was like, okay. I was like, I think we're like underdressed here. We probably should have went someplace else. We were more in Waffle House clothes. We probably should have went to the Waffle House. Yeah, they still haven't. You said they still haven't finished arguing the intrinsic evidence. No, they haven't. Yep, so. Listen and giggle and said, isn't there some standard of not confusing the jury? I can't see how the jury can keep things in order in the YSL trial. I don't either, because I can't keep up and I do this. So I don't know. That is a very good point. Because it's all over the place. It's like you put these people on the stand. They say they lied because they wanted to go home. They lied on people because they wanted to go home. They don't recall any. I don't remember. That was in 1942. How am I supposed to remember that, Miss Love? Look, I mean, come on. Then you had the guy, they took him straight out the hospital bed. And they were like, he's like, I need my Vicodin. I'm having withdrawals. It was like, as a juror, I probably would have been like, why am I here? Why am I making arrangements for my lights and my gas and my mortgage? Why am I here? Oh, this is my civic duty. Oh, okay. So, yeah. Do you think any of the jurors haven't found out why they changed judges? Do your curiosity would be too much? I don't know. It depends on how they probably don't even have people on the jury that are so well versed in the judicial system that they even would look into something like that. I don't know. Yeah. Anyway. All right, y'all. I'm about to get up out of here. So hopefully we'll be back tonight. Y'all know.
And another thing you notice, the first thing they say, make sure you guys hit that like and the subscribe button. That's what it's all about. After they get through dogging you out, before they dog you out, that's the first thing they say. If you like this video, make sure you hit.
You have 1 minute remaining.
I hope I answered all of your questions that you had about this so far. So we're going to see. I mean, I hope you guys understand the importance of why he did this and that I was able to explain that to you so that you guys can better understand. And we'll see what happens on tomorrow. Tomorrow, again, we'll see. They'll still be arguing motions. It sounds like a long, boring day. Yeah, it sounds like we'll probably be there all day. If I had to guess, that's probably what's going to happen. Because they're talking about motion. So we'll probably be back on another day to argue this motion to suppress, because usually you do an evidentiary hearing for that, which is you put on, Miss Fields might have to go, she'll go on the stand and she'll be questioned as to how she got the warrant and what was the reasoning for the impounds and all of that stuff. So, and then the judge will basically make a decision based on an actual full-blown hearing. So that'll be another hearing that will probably come forth on the motion to suppress. So anyways, all right, y'all, I'll let you guys later.